Honourable Speaker.
Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation announcements by the Speaker.
Honourable members, Mr. Prakash Ramada, MP, member for St. Augustine, has asked to be excused from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
The Minister of Works and Transport.
Madam Speaker, I have the honor to lay on the table the administrative report of the Point Lisas Industrial Port Development Corporation Limited for year ending 2014. Thank you.
Minister of Rural Development and Local Government.
Madam Speaker and member for Chaguanas West, thank you. Madam Speaker, I have the honor to lay the following paper. Paper number 2, the administrative report of the Rural Development Company of Trinidad and Tobago Limited for the year ending September 30th, 2013. Thank you, Madam Speaker.
Reports from committees.
Member for Lupino Borneo.
Thank you, Madam Speaker. Madam Speaker, I have the honor to present the following reports. The 9th report of the Joint Select Committee on State Enterprises on an inquiry into the operations of Evolving Technologies and Enterprise Development Company Limited and to determine its effectiveness in fulfilling its mandate to make suitable real estate available to qualified tenants, developers, and operators in a commercially viable manner. And the follow-up report of the Joint Select Committee on State Enterprises on an inquiry into the administration and operations of Caribbean Airlines Limited. Thank you, Madam Speaker.
Member for Caroni East.
Speaker, I have the honor to present the 13th report of the Public Accounts Enterprise Committee on the examination of the audited accounts, balance sheets, and other financial statements of the Union Estate Electricity Generation Company Limited for the financial years 2008 to 2015.
Member for San Fernando West.
Madam Speaker, I have the honor to present the second interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017.
Member for Diego Martin North East.
Madam Speaker, I have the honor to present the following reports. Report number 5, the interim report of the Joint Select Committee appointed to consider and report on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreements Bill 2018. Report number 6, the second interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016.
The member for Laventille West.
Thank you very kindly, Madam Speaker. I have the honor to present the fifth report of the Joint Select Committee on National Security on the final report of the Police Manpower Audit Committee. Thank you.
Prime Minister's questions, urgent questions.
Member for Caroni East.
Thank you, Madam Speaker. To the Minister of Education, given the impending release of the Secondary Entrance Assessment Examination results, C results, and the position adopted by the Trinidad and Tobago Association of Private Secondary Schools, TTAPS, to cease accommodating students, could the Minister indicate the Ministry's alternative plans for students who would be so displaced?
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, students who wrote the SEA 2018 examination have been placed in government-assisted secondary schools, and approximately 300 students have been accommodated at 3 private secondary schools who have agreed to accept students. Madam Speaker, in other words, all students have been placed. Thank you very much.
Supplemental member for Caroni East.
Madam Speaker, I'm a bit baffled. The Honourable Minister has placed, I'm asking him, has he placed students already not having the results of
But is it a question you're going to ask, not a statement? Okay.
Yes, that's a question. Have you placed students not having received the 2018 examination results as yet? That's what you said.
Member? Member for Caroni East. The question has been answered. You're allowed a supplemental question if you wish.
How many students are affected and how many schools are affected by this?
Member for Caroni East, that does not arise from the response that was given. You are allowed another supplemental question.
In view of the alarming statement made by this TTAPS just a while ago, denouncing the Minister of Education, pronouncement, what are you going to do with no support from the TTAPS?
Minister of Education. Minister of Education.
Madam Speaker, frankly, I don't understand the question that is being asked. I have said it over and over again. There is no problem. All the students have been placed. And for the member of County East to continue asking me these questions, it seems as though he doesn't understand, or he has a problem with comprehension, or perhaps he's slow in understanding. Thank you.
Supplemental.
Are you telling this Honourable House and the population, Honourable Minister, that before the examination results are announced, you have placed the students in certain schools? Yeah?
Yes or no?
Minister of Education. Order. Order. Member for Caroni East, I'm certain that you want your question answered. Minister of Education.
Madam Speaker, I'm amazed. The member of County East, being a former Minister of Education for 5 years, doesn't know that there's a placement exercise before the results are released. I just don't understand. Something is wrong somewhere today. Something is wrong.
Order. Order. Member for Caroni East. Member for Miaro.
Thank you, Madam Speaker. To the Minister of Works and Transport, With regards to the recent upsurge of vehicles seeking to be inspected and the ensuing chaos at licensing offices, could the
Member for Miaro, 1 minute. Members, I would like to hear the member for Miaro. I'm having serious difficulty. Member for Miaro.
Thank you very much, Madam Speaker. The Minister of Works and Transport. With regards to the recent upsurge of vehicles seeking to be inspected and the ensuing chaos at the licensing offices, could the Minister indicate whether consideration was given to the use of private testing stations to inspect light T vehicles?
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, at this time, the use of private testing station to inspect light T vehicles is being looked at. However, no decision have been taken. Thank you.
Supplemental, member for Miaro.
Thank you, Madam Speaker. Minister, any idea of how soon a decision may be taken in order to alleviate the issues currently being faced by vehicle owners?
Minister of Works and Transport.
Madam Speaker, this topic is engaging the legal team, and it may require some legislative administration changes, and that is what is being looked at this point in time.
Supplemental, member for Miaro.
Thank you, Madam Speaker. Minister, is there any infrastructural issues that may affect or stop the private testing stations from inspecting the light vehicles?
Minister of Works and Transport.
Madam Speaker, we have 70 operational testing stations at this point in time, and a private testing station, and a comprehensive overview will have to be paid to each one of them to ensure that they have the necessary infrastructure to deal with the light T vehicles.
Member from Naparimo.
Thank you, Madam Speaker. To the Minister of National Security. Given reports of recent riots by frustrated Nigerian detainees alleging violation of human rights, unlawful detention, and inhumane conditions, could the Minister inform this House of the nature and causes of the alleged riots and the action being contemplated to deal with the situation to avoid a reoccurrence?
Minister of National Security.
Thank you, Madam Speaker. Madam Speaker, the nature and cause of the alleged riots are being investigated. The investigation is ongoing, and until such time, remedies to treat with the root causes will be dealt with, Madam Speaker.
Supplemental, member for Naparimo.
Is it correct, Honourable Minister, that on the 5th of January, on a tour of the Immigration Detention Centre, you assured the national community that a better and more humane environment would be created for detainees at the IDC? Yet last week, 7 Venezuelans...
Member, it's a question, so I will allow you to stop before you went on to the Venezuelans. Minister of
Thank you, Madam Speaker. Madam Speaker, as I mentioned at that time, several measures were put in place to treat with the environment at the IDC. And as a matter of fact, the government of Trinidad and Tobago spent a sum of money together using members of the Defense Force and a contractor to treat with the environment. We replaced the air conditioning unit, we dealt with the plumbing, the electrical, to make the environment much more suitable for the detainees at that point in time, Madam Speaker.
Supplemental, member for Naparimo.
Thank you very much, Madam Speaker. Well, could the Minister then explain why last week 7 Venezuelans confronted detainees, confronted the guards, complaining about inhumane conditions? On August the 18th, a Cuban, Johandri Cruz, threatened to sue.
You have 15 seconds to ask the question.
Could the Minister explain why there's a continuous revolt by detainees?
Minister.
Madam Speaker, let me remind the member he spoke about the Nigerians, and that matter is being investigated. And on completion of investigation, remedies will be put in place accordingly.
Member for Faisabad.
Thank you, Madam Speaker. To the Minister of National Security, in view of recent reports that a police officer attached to the Siparia police station has recently contracted tuberculosis, could the Minister indicate what steps are being taken to contain and eliminate any threat to the visiting public?
Minister of National.
Madam Speaker, on behalf of the Minister of National Security, I'll be taking this question. The actions taken to date at the Siparia police station are: 1, a team from the Chief Medical Officer, Public Health Inspectors, PCP2, and a surveillance nurse first site visit at the Superior Police Station has been done. All these started from Monday. Health education and distribution of materials conducted on tuberculosis to staff present. Lecture on hygiene, hand washing, and PPE. Contact tracing conducted, that is everybody who was in contact with the affected police officer. Listing of all staff members obtained. The police maintenance crew, as instructed by the CMOH, the County Medical Officer of Health, has sanitized the facility. We have conducted testing, man-to testing. Secondary health education sessions are already planned. Madam Speaker, I just want to refer to the Newsday article of today, which talks about test result waiting 6 weeks before the results are available. That is patently incorrect. This test, which is the PCR test, does not take 6 weeks, it takes 2 weeks. So those are the measures which have been taken since Monday, and I just want to correct the Newsday article of today, which speaks about a 6-week wait for a test result. That is 2 weeks testing. Thank you very much, Madam Speaker.
Supplemental member for Faisabad.
Thank you, Madam Speaker. Ministers, could you indicate whether any attention has been paid to detained persons or prisoners in terms of testing? To detained persons or prisoners at the police station? At the Superior Police Station?
That is what contact tracing means. I said that already. So contact tracing includes everyone who was in close proximity. Everyone. That is what contact tracing is, which is standard protocol. So that has been done. Thank you very much.
Supplemental member for Faisabad.
Thank you, Minister. Minister, can you then indicate whether the visiting public to the police station is at any risk or has anything to worry about?
As the member knows as a medical practitioner, tuberculosis is contracted mainly through close, prolonged contact. That is, you have to be very close to the person over a prolonged period of time. That is for a normal person with a normal immune system. As you know, a member of the public casually walking into a police station that has already been sanitized, as stated, will stand little or no chance of contracting tuberculosis. Let me reiterate, you contract tuberculosis due to prolonged, close contact, not occasional contact by walking into a facility that has already been sanitized. I thank you very much, Ms.
Member for Point-a-Pierre.
Thank you, Madam Speaker. To the Minister of Energy and Energy Industries. Based on the reported statements of the Chairman of the National Gas Company as it concerns a shortage of natural gas, that choice, and I quote, choices would have to be made as to what plants stayed up. Could the Minister state which plants have been identified for closure, as well as a timeline in which these plants would be closed?
Minister of Energy and Energy Industries.
Thank you very much, Madam Speaker. Madam Speaker, let me categorically state to this House that no plants have been identified in Point Lisas for closure. So therefore, there is no need to indicate any timeline. However, Madam Speaker, the single biggest issue that this government faces on getting into office is the gas curtailment issue. And we as an administration have worked diligently and assiduously to bring this matter under control, led by the Honorable Prime Minister. In 2017, national production was 3.3 BCF per day. In 2018, the estimated average would be 3.8 BCF per day, a whopping 500 million cubic feet more per day. 2019, 4.0 BCF, and 2020, 4.1 BCF. Based on these figures, I see, as Minister of Energy, no serious threat for any closure of any plant in Point Lisas. The NGC has recently concluded an agreement with CNC. We are very close to an agreement with Nutrien. We have concluded agreements with PLNL. And while there are still some challenges ahead, things have stabilized at Point Lisas. And just to set the record straight, I spoke to the chairman of the NGC a while ago, and he indicated that it was just a clip that was taken out of context. The point he was making is that in the international arena, the trend is larger, more efficient plants are replacing the smaller, inefficient plants. And that was the context in which it was made. Trinidad has a suite of plants, some of which are old and inefficient, some of which are large and very efficient. And we are encouraging the Point Lisa's companies with the inefficient plants to invest in energy-efficient technology. Thank you very much, Madam Speaker.
Supplemental, Member for Chaguanas West.
Thank you, Madam Speaker. Would the Honourable Minister state as to the fact that the chairman of NGC made this statement, would not this, given the fact that you have multinationals, transnational corporations operating in Point Lisas, that it is an inappropriate statement for him to make, whatever the context?
I will allow that as a supplemental question.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, there are 3 questions for oral answer. We'll be answering all 3. There are no questions for written answer.
Member for Faizabad.
Thank you, Madam Speaker. Question number 276 to the Minister of Health.
Minister of Health.
Yes. Again, thank you very much, Madam Speaker. The number of vacant positions on the permanent establishment for house officers in each regional health authority is as follows. Northwest Regional Health Authority, 27. North Central Regional Health Authority, 0. Southwest Regional Health Authority, 0. Eastern Regional Health Authority, 2. Tobago Regional Health Authority, 0. I thank you very much, Madam Speaker.
Member for Urupuch West.
Madam Speaker. Question number 280 to the Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam Speaker. Madam Speaker, the completion and operationalization of the Tabaquite packing house is subject to an RFP to be issued by UDCOT within the next few months. Proponents must submit proposals for the modified design, build, equip, finance, operation of the packing house, and the successful proponent must have the ability to provide the full range of operations for the packing house. Interested farmers, farmers groups, members of the public are welcome to submit proposals when the RFP is issued. I thank you.
Member for Urupuch West.
Thank you. Question number 281 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, there is no immediate infrastructure work taking place to accommodate the Cabo Star, as the vessel is actively servicing the route through berth 3 in Port of Spain and the cargo berth in Tobago. For the long term, in order to relocate the operations of the Tobago cargo vessel at the cargo berth at Port of Spain, it will be necessary to undergo dredging work. It is estimated that these work will be completed by March 2019. In terms of the Galleon Passage, 2 additional pile clusters were required to accommodate the berthing of the Galleon Passage at the existing jetty, as the existing jetty is designed for larger vessels. This work has been completed at this time. Thank you.
Supplemental, Member for Urupuch West.
Honourable Minister, what is the estimated cost of the dredging?
Minister of Works and Transport.
Madam Speaker, the dredging work that is being undertaken at the new jetty is maintenance dredging. And I don't have an actual cost at this point in time because the job has not started on the maintenance dredging.
Request for leave to move the adjournment of the House on definite matters of urgent public importance, statements by ministers.
Minister of Energy and Energy Industries.
Thank you very much, Madam Speaker. Madam Speaker, I have been authorized by the Cabinet to make the following statement in this Honorable House. In 2005, the availability of gas fueled the interest by prospective investors in the establishment of gas-based industries in Trinidad and Tobago. One such project was a gas-to-liquids project, which was a joint venture between World GTL Inc. and Petrotrin. The GTL project was intended to produce, for offtake by Petrotrin, high-quality diesel, which would be blended with Petrotrin refinery diesel to improve its quality. Given the environmental concerns, standards for fuels have been upgraded, and Petrotrin ran the risk of not being able to supply markets that adopted the higher standards. This was an intermediate arrangement pending the construction of Petrotrin's ultra-low sulfur diesel project. On September 22, 2005, Petrotrin entered into a project agreement with WGTL to construct and operate a gas-to-liquid plant on Petrotrin's refinery compound at Pointe-à-Pierre. The project economics was based on a plant size of 2,250 barrels per day, a gas requirement of 18.4 million standard cubic feet per day to be supplied either by Petrotrin or NGC, and a gas price of US $1.50 per 1,000 standard cubic feet, escalating at 3%. In January 2006, Petrotrin and World GTL entered into a shareholders agreement in which WGTL held 51% of the equity and Petrotrin 49% in World GTL Trinidad Limited. In early 2007, the budget and funding for the project was finalized. The project budget was the project budget of US $165 million was funded by a loan of $125 million US from Credit Suisse, preference shares in the sum of US $30 million from local investors, and equity in the sum of $10 million US from Petrotrin. The loan agreement with Credit Suisse stipulated that by July 12, 2009, called a date certain, the project had to be sufficiently completed to produce diesel. In the event that the required amount of diesel was not produced by that date, the loan became immediately due and payable. Madam Speaker, the project, as is known nationally, was plagued by delays and cost overruns. And by 2009, the project cost had ballooned to more than twice the initial budgeted cost. Pursuant to the financing agreement, budget increases were to be funded by the shareholder. However, WGTL Inc. was unable to fund its portion, and therefore Petrotrin had to fund in its entirety the cost overruns. Delays in the project meant that production milestones would not be achieved and would constitute a default event under the loan agreement. In order to avoid the event of a default, Petrotrin purchased the Credit Suisse loan. On September 25, 2009, Petrotrin placed the joint venture company WGTL Trinidad Limited into receivership. By that date, the budget had increased from $165 million US to in excess of US $399 million. The appointment of the receiver resulted in the termination of the joint venture and the commencement of arbitration proceeding by World GTL Inc. against Petrotrin for breach of fiduciary duty. The arbitration tribunal ruled against WGTL and ordered the company to pay costs to Petrotrin.
1 minute. Members for Oropouche East and Caroni East, while I would entertain you when you wish to speak, it would be at the proper time. I'm being disturbed. Minister of Energy and Energy Industries.
Thank you, Madam Speaker. With the termination of the joint venture,
Petrotrin moved to complete the project. By the end of 2010, Petrotrin ceased funding for the completion of the project. Accordingly, Madam Speaker, the receiver shifted the focus to the acquisition of an investor to complete the plant. Following an open process, the receiver identified Naikwan as the prospective investor. By letter dated 16th April 2012 to the receiver, Naikwan Energy LLC submitted a proposal in response to the RFP. And by letter dated 6th July 2012, the receiver notified Naikwan Energy LLC that it had been selected as the prospective investor. In October 2014, the Petrotrin board approved the receiver's recommendation of Naikwan as the preferred investor. The receiver then entered into negotiations with Naikwan on commercial terms for the acquisition of the plant. Arising from the negotiations, a price of US $35 million, comprising of initial payment of US $10 million and preference shares to the value of $25 million payable in 2 equal tranches was proposed. Naikwan reached final agreement on the commercial terms and all other outstanding issues on or about 5th of August 2015. The proposal was accepted by the Board of Directors, and the transaction was subsequently sanctioned by the Minister of Finance. August 2015. In 2016, a sales and purchase agreement, SPA, was executed among WGTL Trinidad Limited in receivership, the receiver, and Naikwan. The closure of the SPA is subject to the fulfilling of conditions precedent, which include the securing of a gas sales contract for a guaranteed supply of natural gas for the period of the product offtake agreement with Petrotrin. All of the agreements and conditions precedent, save and except the gas supply contract, had been satisfactorily settled. A gas supply term sheet was executed between Naikwan and NGC in November of 2014 for 26.5 million cubic feet per day. However, NGC and Naikwan were unable to agree on price and duration. NGC supported the project, but given gas curtailment claims of $4.6 billion against it, was of the view that a gas supply to Naikwan would expose it to unacceptable legal and commercial risks. Given the NGC situation, the project was now at a standstill. The option available were either to proceed or to discontinue with the project. If the latter option was pursued, the plant would have had to be dismantled at a cost and sold as scrap. If the project is pursued, financial benefit would accrue both to Petrotrin and the economy. In order to salvage the project, Naikwan approached the government for support in acquiring a supply of gas of approximately 31 million standard cubic feet per day. A review of the project suggested that it was worthy of government support. The financial benefits include US $35 million payment to Petrotrin, a capital injection of US $125 million into the economy, and $2 billion in taxes and statutory payment over the life of the project. During the construction phase, which is projected at 12 months, 700 new jobs will be provided. And on completion, there will be 65 skilled permanent jobs and 650 indirect supply chain jobs. Given the delay in the completion of the Petrotrin's ultra-low diesel project, the offtake from the GTL plant will allow Petrotrin to meet in the interim environmental standards for gas oil. As at October 2013, Petrotrin has been unable to supply the gas oil requirements of member CARICOM states as the marketers have moved to low sulfur gas oil. With effect from January 1st, 2020, Petrotrin will be unable to supply bunker fuel to ships unless it meets the new global limit of 0.5% sulfur mandated by the International Maritime Organization. Following a review of the project, the government agreed to support the request by Nikwan Energy Limited for a supply of 31 million standard cubic feet per day of natural gas for its gas to liquid project, and that consideration be given to the sourcing of the natural gas from arrangements that exclude the NGC and which are on commercially acceptable terms. The Ministry of Energy and Energy Industries has negotiated and agreed with Nikwan the terms of the gas sale contract. Cabinet approved the gas sales contract, which has been executed on behalf of the government by the newly incorporated state-owned energy company, Trinidad and Tobago Upstream Downstream Energy Operations Company Limited. It is the intention that selected energy assets of the state will be held by this company. Madam Speaker, the Nikwan project provides Petrotrin with the opportunity to salvage some not insignificant benefits from an investment which otherwise could not be operationalized. In a wider context, the economy and state stands to benefit from increased commercial activity and taxes. Nikwan requires a maximum of 31 million cubic feet per day of gas, which is not substantial, and in the current context of 3.8 BCF per day, amounts to a mere 0.8% of daily gas supply. Madam Speaker, given projections for gas supply, this requirement can be met, and thus finally, and let me repeat that, and thus finally, this project can now proceed to completion under this administration.
Member for Chaguanas West.
Standing Order 24-4, elucidation. Could the Minister indicate whether or not, given the fact that this is a brand new gas agreement, NGC is not associated, would you lay that gas agreement in this Parliament in the context of transparency?
Minister of Energy and Energy Industry.
As is well known on both sides of this House, gas sales agreements are subject to confidentiality clause. So obviously, it cannot be laid in Parliament.
Order, order, please. Member for Port of Spain, North, St. Anne's West. And I welcome all assistance, but I wish it will be cooperation with the standing orders. Thank you very much. Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, over the last several months, the opposition has made a number of accusations and allegations regarding the purchase of the Galleon Passage RoPax, or roll-on, roll-off passenger vessel. The allegations include that a broker by the name of James Aitkenhead from International Broking Services was used to acquire the vessel for an undisclosed fee. Madam Speaker, really? They're being ridiculous.
Members, particularly Oropuch East, Caroni East, a warning in anticipation, and Couva South. I don't know if you all don't recognize that your mics maybe sometimes are on, so that your comments reach me. All right? So let's take heed, and let's avoid my having to stand up to address the three of you all again. Honorable members. Member for.
Thank you, Madam Speaker. Can't help it. The allegations include that a broker by the name of James Aitkenhead from International Broking Services was used to acquire the vessel for an undisclosed fee, that the valuation used by the government to make the decision to purchase the vessel was done by a company owned by the seller of the vessel and was thus not credible, that the vessel was purchased from Sea Transport Solutions and the payment for the vessel was sent to the bank accounts of private individuals, that the vessel is an old vessel that has been sailing all over the South China Sea since 2016, and that the original purchase price for the vessel was US $15 million, and it is now only worth $6 million. Madam Speaker, all of these allegations are false. The true facts are as follows. Contrary to the false allegations made, initial inquiries were sent to a number of international shipbrokers, ship managers, ship owners, and ship builders. During this process, the owner of the vessel, Sea Lease Limited, became aware of the government's worldwide search and contacted the government directly and informed the government that a newly constructed vessel that broadly met the requirements for the inter-island ferry service was in its final stages of completion and was available for purchase. The vessel was thus purchased directly from the seller, and no broker was involved in the sale and purchase transaction, and as such, no broker fees were paid to anyone. 2. The sale and purchase agreement between Sea Lease Limited and the National Infrastructure Development Company Limited, the bill of sale and the registration certificate for the vessel in the name of NIDCO are being circulated in this house today to put an end to all of this old talk. Contrary to the allegations of the opposition, these documents make it clear who the parties to the transaction are, who was paid for the vessel, and who owns the vessel. It should be noted there is no reference to any broker in the sale and purchase agreement. And if I digress, we have even included the bank account of the seller, so you can go and follow the money if you want. As part of the package of documents received by the government for the vessel, a valuation of US 19 million was submitted by a company called Oceanic Design and Survey. It was clearly stated in this valuation report that this company is affiliated to Sea Transport Solutions, which is the designer of the vessel. As such, the government engaged a highly reputable ship valuation firm by the name of Schulte Marine Concept, who valued the vessel at US 35 million. The two valuation reports are being circulated in this house today. Contrary to the allegations made, the final sea trial for the vessel was done by the seller on the 30th of October 2017. Sea trials represent the last stage in the completion of a vessel, and it is thus impossible, as falsely alleged, that the vessel was sailing all over the South China Sea since 2016. The certificate of registry, synopsis record from the Vanuatu Sea Registry, dated February 8, 2018, also clearly states that the vessel remained in shipyard until transferred to current ownership and vessel name changed. Let me say that again. The Vanuatu Registry confirms that the vessel remained in shipyard until transferred to current ownership and the vessel name changed. Madam Speaker, to summarize, the following documents are being circulated in this House today. The Memorandum of Agreement, the Norwegian sale form for the sale and purchase of the vessel, executed on the 12th of January 2018 between Sea Lease Limited of Hong Kong and the National Infrastructure Development Company of Trinidad and Tobago, NIDCO, together with the bill of sale and associated documents lodged with the Vanuatu Commissioner of Maritime Affairs. 2. Certificate of registry from the Republic of Vanuatu for the vessel in the name of NIDCO and associated documents dated February 8, 2018. Valuation report for the vessel done by Oceanic Design and Survey. Evaluation report for the vessel done by Schulte Marine Concept over the period 4th to the 6th December 2017. Design specification for the vessel prepared by Sea Transport Solutions. Pre-purchase condition survey done by Lloyd's Register Classification Society, China Limited, dated December 10th, 2017. And the sea trial report for the vessel from Guangdong Bonifair Heavy Industry Limited, the shipyard, for the period 2016 to 2017. And I hope this now puts all of these false allegations to rest. Thank you, Madam Speaker.
Member for Caroline East.
Honourable Minister, are you prepared to release the identity of the insurance companies, both local and foreign?
Member, this was raised in accordance with Standing Order 24-4, I believe, right? And I don't know that this is for the purposes of elucidation based on the statement that was issued.
That he just made, Madam Speaker. He left it out.
Member, I have ruled that this is not for the purposes of elucidation. You can raise under 24-4 based on something he has said for elucidation.
Personal explanations, introduction of bills, the Planning and Facilitation of Development Amendment Bill 2018 in the name of the Minister of Planning and Development, motions relating to the business or sittings of the House and moved by a minister.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report by September 14th, 2018. Thank you very kindly.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017 be allowed an extension of 11 weeks in order to complete its report and submit a final report by September 14, 2018. All in favor say aye. Aye. Any against? I think the ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreements Bill 2018, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report by September 14th, 2018. Thank you very kindly.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreements Bill 2018 be allowed an extension of 11 weeks in order to complete its work and submit a final report by September 14th, 2018. All in favor say aye. Aye. Any against? I think the ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016, I beg to move that the committee be allowed an extension of 11 weeks in order to complete its work and submit a final report by September 14th, 2018. Thank you very kindly.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016 be allowed an extension of 11 weeks in order to complete its work and submit a final report by September 14th, 2018. All in favor say aye. Aye. Any against? I think the ayes have it.
Public Business Committee business motions.
Honorable members, the debate on the following motion, which was in progress when the House adjourned on Wednesday, June 20th, 2018, will be resumed. Be it resolved that this House adopt the report of the Joint Select Committee appointed to consider and report on the Anti-Terrorism Amendment Bill 2018. Attorney General.
Sure. Thank you, Madam Speaker. I'm a little surprised. But in any event, it gives me great pleasure to draw conclusion to this motion to adopt the unanimous report of the Joint Select Committee established to consider this very important piece of law. Madam Speaker, you will recall that we last debated this 1 week plus ago. It was at that time that the leader of the opposition and several members of the opposition bench indicated to the government that more time was needed to have a discussion on certain aspects of the work of the committee in the draft legislation which was brought under cover of this report. Indeed, the government was pleased to allow that opportunity to prevail. Regrettably, we have not managed to have a conclusion of even an agreement to meet between government and opposition. And for the record, I now wish to put the following into position. First of all, on the date that we last met, we agreed that we would stop, have a discussion. The leader of the opposition indicated that there were amendments that the opposition was considering and that at some point we would receive that. Indeed, I was under the impression that those amendments were in fact in written form on the last date of sitting. I spent a considerable amount of time, and I thank the leader of the opposition for responding to my several text messages. Both the leader of government business and I have been in constant communication with my learned friends opposite, in particular the member for Pointe-a-Pierre and the member for Siparia. The member for Siparia indicated to me that she had herself prepared written amendments, but that she was not in a position to send those because they resided on her computer, and that she would have to get it to me at some point. After that, we then went into a constant requesting position for the amendments that the opposition considered were necessary to the work of the Joint Select Committee. We have not received that. We wrote to the opposition asking that we, in fact, meet. We were tentatively scheduled to meet last Friday. We again tried, by way of written correspondence, to meet on Wednesday. We attended at the Parliament, the government benches, to meet on Wednesday, and regrettably, the opposition did not show up. I thank my learned friend, the member for Pointe-a-Pierre, for writing me in response to my own letter to him expressing my disappointment that we had not met on Wednesday as scheduled by the and facilitated very kindly by the Parliament in having the room available for us. And for the record, my learned colleague, the member for Pointe-a-Pierre, indicated in essence that there was, from his understanding, not a confirmed position for a meeting, but specifically, my learned colleague had this to say. At this Friday, June 29, 2018, upcoming sitting, the opposition bench has several speakers carded to contribute on this issue, and as a result may be presenting further amendments to the Anti-Terrorism Amendment Bill 2018. All amendments would be forthcoming during the proceedings of the debate. This is why I expressed surprise that no one opposite was standing to contribute, because the government is fully prepared to take on board the suggestions of my learned colleagues who have, in the course of the Joint Select Committee, done excellent work with the government in coming up together with a unanimous report of the Joint Select Committee. I note that I have not yet, as I stand now, as Attorney General, leading the consideration of this bill, received any written amendments from my learned colleagues. In those circumstances, I'm compelled to try to address proposed amendments from that which I have gleaned during the course of the presentation of my learned colleagues. But permit me, Madam Speaker, to put this law into context. I think it's safe to say that the opposition and government are agreed that anti-terrorism law is necessary and is important. It is necessary and important for two purposes. Firstly, in the local context, to treat with the reality in Trinidad and Tobago that we have persons who have named themselves internationally as supporters of terrorist ideology. And we also have persons who have gone on to television networks, the National Geographic Channel is one of them, and have admitted that they not only supported terrorist ideology, but were engaged in active recruiting of persons. Those two examples alone tell us that that's enough. I personify the first example in the name Shane Crawford, who calls himself Abu Sa'ad a Trinidadi, In Arabic, when you have a name Al-Rawi, for instance, my name, it means the person and the district usually is Rawi. Al-Trinidadi means you're from Trinidad. So we've got Shane Crawford telling the world that he's from Trinidad and that he is encouraging Muslims in Trinidad and Tobago to take up arms against the state and support ISIS philosophy. That was done internationally in the Dabiq magazine. And we also have a gentleman by the name of Omar Abdullah, who has been featured on a National Geographic program and who is a citizen of Trinidad and Tobago, representing himself as a Muslim leader in this country, who has said to the world that he at one point supported ISIS ideology and philosophy. I must add, Shane Crawford was detained under the state of emergency called by the member for Siparia when she was Prime Minister, the Honourable Member. Shane Crawford, the same Shane Crawford, was arrested and detained by my friends opposite. So we are agreed that this phenomenon is something that we must treat with, that there are examples in our society. But let me turn now to the international dynamic, Madam Speaker. Let's turn to the international dynamic. Why are we doing this in an international context? We're doing this, Madam Speaker, because Trinidad and Tobago agreed in many years of successive steps that we would submit ourselves to the international treaties brought on by the United Nations. Indeed, the member for Naparima reflected upon it in his contribution, and the Honourable Member was correct in making that observation. Trinidad and Tobago started this journey in April 1995, when we had our first round mutual evaluation by the Caribbean Financial Action Task Force. 1995. June 2002, we had our second round mutual evaluation. In May to June 2005, we had on-site visits, etc. And in 2005, our Anti-Terrorism Act became law in Trinidad and Tobago, and there is a legislative history of that. Madam Speaker, it was through February 2012 and February 2013 that my learned friends opposite the UNC government dealt with the FATF recommendations and committed Trinidad and Tobago in the CFATF arena to be the first country in the CFATF, then 27-country basin, to undergo what is called the fourth round mutual evaluation, where they test two things. One, your technical compliance. Do you have laws to treat with certain things? And secondly, your efficiency. Are your laws working, and what evidence do we have? As a result of observations in the third round and fourth round mutual evaluation process, and in getting to the on-site examination in January 2015, Trinidad and Tobago found itself obliged to amend our laws. And indeed, my learned friends opposite amended the Anti-Terrorism Act, the Financial Intelligence Unit legislation, the Proceeds of Crime Act, the Financial Obligation Regulations, the Central Bank Act, the Exchange Control legislation, a host of subsidiary laws in 2010, 2011, 2012, 2014, and 2015. That's what my learned friends opposite did. Today we come now, having got our fourth round mutual evaluation. We were committed to it by my learned friends opposite. I can't say that it was a pleasure to be the first country, one of the first countries in the world to undergo fourth round mutual evaluation, but so the die was cast and we entered into it. Upon becoming government, forming this government in September 2015, Trinidad and Tobago became the chair of the Caribbean Financial Action Task Force. The Attorney General of Trinidad and Tobago, I as its office holder, became the chair of the Caribbean Financial Action Task Force. And in that, we went through our fourth round mutual evaluations report, and in June 2016, that report was adopted. And Trinidad and Tobago went into two specific routes. Number one, we fell into something referred to as enhanced follow-up. That is at the CFATF level. And secondly, we went into something called the ICRG process with FATF. So we had two bodies looking after us. The ICRG is the International Cooperation Review Group, which is a body of FATF which looks at Trinidad and Tobago. In dealing with this, starting the journey since 1995, the international framework is very deliberate and very specific. You are required to give an action plan. You are required to say when you are going to address your deficiencies against the 40 recommendations and the immediate outcomes, the 10 of them, and you are obliged to stick to your timelines. Madam Speaker, the amendments which we seek to do in this bill are being watched by our International Cooperation Review Group and CFATF. And Madam Speaker, they're also being watched by other entities, in particular the Global Forum and the European Union, the European Parliament. If you do not, if you do not comply with your obligations, you are going to fall into the realm of enhanced due diligence. What does that mean? The banks say to you internationally, we will not do business with your country because you have moved from what they call grey listing into what you are called blacklisting. Trinidad and Tobago is currently on the network of what is colloquially referred to as a grey list. We are published by FATF in the Improving Global AML CFT Compliance ongoing process. FATF has looked at us. They have a mechanism called a joint group review, where the Attorney General and team must attend before the Americas group. It's next scheduled for September 5th, 2018. We last had one in September 2017, and you are committed to an action plan. Madam Speaker, if we do not complete the amendments to this law today in the House of Representatives to allow us to go to the Senate, we will not complete the timeline that FATF has set out for us to be able to report on September 5th as to where we stand. And specifically, Madam Speaker, I must put on record, the European Parliament is in fact applying sanctions to Trinidad and Tobago. We have been put into deficiency by, for instance, South Korean cryptocurrency exchange and the European Parliament, where they have mischaracterized our status on the compliance document that I've just referred to. And the banking sector in Europe is currently stopping banking transactions and brokerage transactions with Trinidad and Tobago entities. So even though we are not supposed to be treated with enhanced due diligence, not supposed to be blacklisted, the European Parliament has mischaracterized the FATF report. So, Madam Speaker, imagine if we don't achieve the bill, what will happen? For Trinidad and Tobago's sake, I ask you to note that the Attorney General's office has written to CARICOM. We have written to the President of FATF. We have written to CFATF. It's going to be raised at the heads of CARICOM meeting next week in their session, where the Honorable Prime Minister will take the lead on this. Every Attorney General from the CARICOM countries has agreed to support Trinidad and Tobago through my own advocacy, and we will be taking the charge to the European Parliament and to FATF to make sure that not only Trinidad and Tobago is not treated with negative consequences, but that the rest of our CARICOM countries, which are following behind us in their fourth round mutual evaluation, don't find themselves in the position of blacklisting and sanctions when it should not happen. I just wanted to put that into context to let the honorable members opposite know that in taking our time to treat with this legislation, in treating with the very many meetings, 12 meetings on the record, at least 3 other meetings off the record in the Joint Select Committee, we have taken a generous amount of time to consider the amendments to the anti-terrorism bill. We have engaged in wide stakeholder consultation. We have had public hearings. We have received commendation, both government and opposition, for our positions. the international entities have also been speaking with us. Indeed, the government encouraged all international entities, foreign states, to engage not only government but opposition as well. The United States of America has engaged us both. The United Kingdom has engaged us both, opposition and government. And this is at this government's request, so that it isn't going to be just a government-driven agenda, because my learned friends opposite are required to support the improvements to our law. Now, Madam Speaker, I want to put onto the record that the legislative history of the Anti-Terrorism Act is very important. The Anti-Terrorism Act 2005 was not dealt with by way of special majority. The Anti-Terrorism Act, which was amended by Act number 2 of 2010, had a 3/5 majority. The anti-terrorism amendments, which came by Act number 16 of 2011, was a simple majority dealt with by Brigadier Sandy for the UNC government. The anti-terrorism amendments that came by Act number 14 of 2012, dealt with by Attorney General Ram Logan for the UNC government, had a 3/5 majority. The Anti-Terrorism Act 2015, which was amended, by Act number 15 of 2014, dealt with by Minister Hawaii for the UNC government, had a special majority clause. And Madam Speaker, I'm pleased to say that the PNM opposition supported every single amendment made, whether simple majority or special majority, without a whimper of negativity inside that equation. No fuss, no hindrance. Now, Madam Speaker, let's get to the observations of my learned friends opposite. We've been through the purpose of the bill. We've said what the structure is. We're cautioning that we are being treated by way of mischaracterization. There's active blacklisting, which should not happen. There's active enhanced due diligence being applied against Trinidad and Tobago. Our economies are suffering and have the risk of suffering more if we don't get this right. So let's deal with the pause. We took a week off plus. We tried to meet. We tried to get amendments out of the opposition. My learned friends opposite in their contributions made certain observations. Let's go to the observations. The observations of my learned friends. Madam Speaker, what is the precise time I must end in full time?
You have 2:49:29 as your original time. You have an extended 15 minutes after that.
Thank you, Madam Speaker. So just after 3. Thank you, Madam Speaker. 3 or 4. Madam Speaker, let's get to how this law works when we consider the amendments that my learned friends have said on the floor, postulated over, and which I welcome from my learned colleagues opposite. The Anti-Terrorism Act is built upon two particular structures: the civil end of the anti-terrorism law and the criminal end of the anti-terrorism law. Our anti-terrorism law defines a terrorist act. It is treated with by way of extraterritoriality, meaning if you're a Trinidad and Tobago citizen and you are found guilty of or suspected of committing an offense under the anti-terrorism laws, it can apply with respect to acts which are committed abroad. The criminal end of the equation is managed by the Commissioner of Police conducting investigations and by way of the Director of Public Prosecutions being involved in that process. It is treated with by way of proof beyond reasonable doubt, and proof beyond reasonable doubt is the standard for criminal prosecution. On the other side of the equation, we're treating with the civil law. The civil law is managed in accordance with our Constitution, Section 76(2) of the Constitution of the Republic of Trinidad and Tobago, so described as the supreme law by Section 2 of the Constitution, says that the Attorney General for Trinidad and Tobago, whomever is the office holder, is effectively in charge of civil matters in our democracy. In the civil side of the anti-terrorism law, the Attorney General is vested with a very important feature, and that is specifically under Part 3, Part 3A of the legislation, where we are treating with the matters of listing of entities, individuals designated entities, or any other entity that may be involved in terrorism, the Attorney General falls and comes into action under Section 22B of the Parent Act, where the Attorney General approaches the Court of Trinidad and Tobago, the High Court, asks a judge to consider the matter, and then the entity, individual, is or designated entity, and a designated entity is an entity which the UN has designated. The court considers the application and may or may not grant an order which freezes and organizes the affairs of persons on the civil side. So you list the entity under Section 22B, and then the freezing mechanisms kick in after that. That has been the law. Starting in 2005 when the Act came in, put into effect in the 2010 amendments when Part 3A was inserted, improved by way of amendments under the UNC government in 2011, 2012, 2014, 2015, and it has been available for use by any Attorney General for the entire time that the law stood. In September 2015, there had been no listings ever done in Trinidad and Tobago, and the Act was effectively virgin territory. No listings, no terrorist financing, no prosecutions for criminal activity considered to be terrorism. Zero. In September 2015, we took the decision to operationalize the anti-terrorism law. The Attorney General's office created the anti-terrorism desk, and we went to work, and today we have listed 357 entities. We have gone to the United Nations, we have listed designated entities there, we have reciprocated here, we have incorporated a task force, which is a comprised law enforcement agency and Attorney General task force called Task Force Charlie, where we coordinate the entities as we're supposed to under law. We have done the operationalization of this law. So I wanted to explain the substrata of it before I come to the amendments. When we look to the amendments that I have gleaned from my learned colleagues opposite, through the contribution of the Honourable Member for Siparia, noted, firstly, that there was an inadvertent maintenance of an Arabic name in Section 2 of the Act, Clause 5 of the bill. My learned friend opposite noted the reference to Taliban, and that reference to Taliban should have been removed because we had agreed as a formula for approach that we would refer to the 1988 committee, meaning the Sanctions Committee established by the UN and Article 30 of the UN SCR Resolution 1988. Taliban is an Arabic word. In Arabic, Talib means student. Taliban is the plural for students. It just means students, students of Islam. So we are proposing, consequent upon the observation of my learned colleague for Siparia, that be attended to by way of an amendment to remove the reference to Taliban. My learned friends opposite proposed that in the new feature of the proposed Section 15, where we're inserting that by way of Clause 22, that we should in fact allow for the order which the Minister of National Security can make where a part of a territory, a part of a state can be declared as a declared geographical zone, that we in fact put that subject to negative resolution of Parliament. We think that that is a very sensible solution. It was something which we discussed in the committee, the Joint Select Committee. We featured upon it, but the committee decided not to put it in there. There is no objection to it being reverted now and put in there because it can only provide for more ventilation of a designated entity in the event that there's a debate over it. That would add to the fact that the committee itself, the Joint Select Committee, recommended that the Leader of the Opposition be informed of designations to include that feature into our law. Madam Speaker, we are also now to observe another observation by my learned colleagues opposite, again in Clause 22 of the bill. The Honourable Member for Siparia noted that whilst we had provided a specific time frame of 30 days for adults to inform the Commissioner of Police of certain matters when they return to Trinidad and Tobago, that we had not put in a similar provision for children and therefore the recommendation made by my learned colleague for Siparia has found favor with the government, and we propose that we also include the similar prescription for 30 days, applying by way of an amendment to what is section 15D as it is proposed in clause 22, where we add that the person shall give notice no later than 30 days upon return to Trinidad and Tobago. My learned friends opposite also made reference to the need for a report to be laid in Parliament. And it is something which, in fact, did not feature in the parent law. There is no requirement for a report. We think that it is useful to have a specific report on the Anti-Terrorism Act, and therefore we propose that that suggestion be accepted by the insertion of a new 22BF, where the Attorney General shall cause to be prepared and laid in Parliament an annual report on the number of entities listed in accordance with 22B. Madam Speaker, we noticed, and this is not an observation coming from my learned colleagues opposite, but we noticed that clause 28 of the bill inadvertently maintained the use of the word "the committee," and that did not therefore pick up the manner in which we proposed to treat with the committee, because it didn't expand it to the 1267, 1989, and 2253 committee, and therefore we have just cured that to bring it in keeping with the other places where we use the same formula. So we are proposing that clause 28 of the bill be treated with in similar language to that which we've agreed for the use of the replacement of "the committee," the use of the replacement of the Arabic words reference, Taliban, etc., and that we replace those with this formula. It now brings me to the core observation, which I had some difficulty with, made by my learned friend for Siparia, and that is that there was an expression of discomfort that the Attorney General featured in the formulation of an investigation. And let me center onto that in what section 22AA and section 22B, etc. of the Parent Act, as is proposed to be amended, treats with. Madam Speaker, in the formula accepted by the Joint Select Committee, that feeling of an executive person being involved was discussed. But let me treat with it from the parent law, work my way back. In the Anti-Terrorism Act, there are three very important sections which are the existing law that I want to refer honorable members to. They are section 25 of the Parent Act, section 33, section 32 of the Parent Act, and also section 37 of the Parent Act. And I'll add into that section 33. So let me repeat. 25, 32, 33, and 37. This is the existing law as it stands before the committee even went to work. These sections fall under Part 5, beginning at Part 5 of the Act, Jurisdiction and Trial of Offences, and Section 25(3) of this Parent Act is very important to consider the observations in relation to the Commission of Police and the Financial Intelligence Unit. 25(3) says this: where the Attorney General receives information that there may be present in Trinidad and Tobago a person who is alleged to have committed an offense under this Act, that is anybody, the Attorney General shall cause an investigation to be carried out in respect of that allegation. So that's 25(3) of the existing law as it existed under the UNC government, the PNM government, and now a PNM government again. Section 32, which is under Part 7, Disclosure and Sharing of Information, says this specifically. 32, every person or regulatory authority who has any information which will assist in preventing the commission by any other person of a terrorist act, securing an arrest or prosecution of another person for an offense under this act or an offense under any other law, and which also constitutes a terrorist act, shall forthwith disclose the information to a police officer or the central authority, as defined under the Mutual Assistance in Criminal Matters Act. So the central authority under the Mutual Assistance in Criminal Matters Act is the Attorney General of Trinidad and Tobago.
30 minutes are now spent. You're entitled to 15 more minutes if you so wish.
Should it please you?
You may proceed.
Thank you, Madam Speaker. Madam Speaker, let's go to subsections in Section 32. Notwithstanding subsection 1, a person referred to in 1 shall not be required to disclose information which is protected by privilege. 3, civil or criminal proceedings shall not lie against a person for disclosing information in good faith. 4, person who fails to comply commits an offense. 5, for the purposes of this section, listen to this one, regulatory authority means the central bank, the Securities Exchange Commission, the Financial Intelligence Unit, the Trinidad and Tobago Stock Exchange, the Inspector of Financial Institutions, and the Commission of Cooperatives. So that's the existing law, 25.3, 32, Section 32 now of the Parent Act. Section 33, every person shall disclose to the FIU. And 33.2 says, the FIU shall disclose to the appropriate authority any information in his possession relating to terrorist property if such information is requested or if the minister is of the view that the information would be relevant. 33.6, every person who fails to comply commits an offense, etc., and there's the exception for good faith, etc. Section 37, the Attorney General may make an application to a judge for an order of forfeiture, etc. Now, 22, sure.
Would you be kind enough, as you're going through the parent law, why it is you want to change those, what is the existing law with respect to those sections? What is the problem you're having with the existing section?
I thank my learned colleague because that's spot on. Good question. Having had the benefit of applying for 357 orders for listing of entities, what came, pardon? Yes, which have all been successful. These are orders of the court, the High Court of Trinidad and Tobago. What we found was that there was a need to put in a process flow into Section 22A, AA, and into Section 22B. And it achieves two purposes. So it's born on the back of experience in court, but it's also born on the back that the interrogators of our legislation from the joint group, which is the joint group of the Americas, which looks at us at the ICRG process at FATF, that is very much born out of a civil law system where they're very prescriptive in the language which applies. And other jurisdictions around the world, and I've traversed all of the Commonwealth and the FATF countries, all of the jurisdictions around the world have a similar prescriptive matrix. So why borrow from 25, 33, 32, 37? Specifically, we propose in clause 22AA that we add in a subsection D to section 2. In 22AA, we're saying, for the purposes of a section 22B application, that is a listing of an entity, a designated entity or an individual, for the purposes of section 22B, the FIU shall be responsible for, and here's the bit, furnishing the Attorney General with information required to facilitate an application under 22B and section 37 spontaneously or upon request. So we're not just going for a wide-ranging application. It is specifically for section 22B listings, civil end listings, and section 37, which is the forfeiture provisions that we get into. But what we think is opposite here is that we actually factor a small amendment, because my learned friend for Siparia observed, as she did, which caused the government to have a double look at what we did for the Commissioner of Police. The Joint Select Committee unanimously agreed that the Attorney General may ask the Commissioner of Police for an investigation, and the Commissioner may conduct an investigation, but that the Commissioner, at the end of his investigation, may inform the Attorney General not of everything, but of the relevant particulars. Because what is relevant is what is relevant for Section 22B. That is the listing. We believe that similar to that amendment, that we can perhaps treat with a small amendment to Section 22AA, as we propose in the bill that it be treated with, and allow for the FIU to only give relevant information. So we propose that we use the same formula that the Commissioner of Police is bound to observe, as recommended by the Joint Select Committee unanimously. We propose that that be treated with for the FIU as well. So, Madam Speaker, 22AA, which we propose to have amended, we propose that, well, we ask my learned friends opposite to bear in mind the Constitution, Section 76(2), it's the Attorney General that does civil matters. Section 22B, the listing of entities is to be done by the Attorney General. It's a civil law process. It's been the law under the anti-terrorism laws in its entire history, beginning in 2010, when that amendment was introduced. So between 2010 to now, it's the existing law. 3, under the Mutual Assistance in Criminal Matters Act, the Attorney General is the central authority. The Attorney General has the ability and in fact engages in a direct discussion with the Commissioner of Police as well as the Director of Public Prosecution in relation to matters including evidence and charges of a criminal nature. And therefore one ought not to be disturbed as to the mere mention of an executive function. Further, in the Commonwealth and in the Caribbean Commonwealth, it is demonstrated that there is ample precedent for the Attorney General or another functionary of an executive nature that is an elected government to actually be involved in this process. And I wish to refer to Antigua and Barbuda, the Bahamas, the United Kingdom, Australia, Canada, where the Minister of Foreign Affairs, for instance, in Canada, can cause the listing, where the Secretary with responsibility under the United Kingdom formula can cause a process to be done, where the Attorney General in Bahamas, the Attorney General in Antigua and Barbuda causes this functionality. So there is ample precedent. But Madam Speaker, permit me to be very careful to say, whilst we tour the legislative environment around the world, as we borrowed, for instance, in the designation in the section 15s which we create, this declared geographical zone we borrowed from Australia, I want to put on the record something which is extremely important, Madam Speaker. We are not comparing apples with apples. In the United Kingdom and in Australia, there are very different and very draconian measures of law that operate in their environment. And that is something which we must be extremely careful to remember. Because when we look to the UK experience as a matter of priority, the United Kingdom has very important purpose in its law. And permit me to put this into the record. I thought my learned friend was going to speak. Madam Speaker, the United Kingdom has, in its Criminal Justice and Public Order Act 1994, sections 35 and 37, listen to this. It allows an inference to be drawn when a defendant is silent at trial. This section is something which allows an inference to be drawn where a person fails or refuses to account for objects or substances or marks found on his person, etc. The United Kingdom secures the vast majority of its convictions for terrorism in the exact opposite of our Constitution. In our Constitution, in Section 5, you have the right, effectively, to remain silent. It's the right against self-incrimination. In the United Kingdom, if you remain silent, it's an adverse inference. And the vast majority of their convictions come on that basis. But in the United Kingdom, there is limited disclosure. In the United Kingdom, you can be arrested without a warrant. In the United Kingdom, your detention can be extended unilaterally by the police. In the United Kingdom, they can sequester and limit the involvement of the defense. So they are not obliged, as under our laws for disclosure in the criminal law arena, to show the weakness of your case. It's the exact opposite of our judicial system. Australia has similar mechanisms. The United States has similar mechanisms. So when we hear, bring in a reviewer, bring in special procedures, do it this way, the need for independent involvement of entities in these other jurisdictions is essential, because you could be locked up and lost in Guantanamo Bay like that. And that's the vast difference between our systems. Furthermore, our criminal law environment has a sacrosanct standard of proof. Proof beyond reasonable doubt, where we do not have limitations on evidence. How many convictions do we have for terrorist financing and for terrorism? 0. The only leg of the equation that is working exceptionally well is the civil law end under the Attorney General, as our government has now successfully demonstrated. And Madam Speaker, what is required in this rubric is for us to recognize that our judicial, legal system, our laws and our constitution are remarkably different from the comparators that are being brought as appropriate comparators to cause change to our laws. Madam Speaker, I urge my learned colleagues opposite to recognize that the battle against terrorism is a certain and real one for all of us. My learned colleagues have certainly enjoyed the benefit of the law standing the way it was from 2005 straight up to when they left office. The power of the Attorney General and involvement on the civil law side has been the law for the longest while, since 2010. Section 25, Section 32, Section 33, Section 37 of the parent law, the Mutual Assistance in Criminal Law Matters Act, which is by which the central authority comes to life in extradition, the FIU laws, the FOR laws, the Securities and Exchange laws, and the Supreme Law of Trinidad and Tobago, the Constitution, all provide for this mechanism. This is the day. This is the day that the world is looking at us. And if any one of us think that the world is not looking at us, we have to think again. I know that the Department of Justice in the United States of America is looking at us now. I know that the United Kingdom is looking at us right now. I know that Canada is looking at us right now. Australia is looking at us right now. FATF is looking at us. CFATF is looking at us. Jamaica and Barbados are, as a matter of fact, as I spoke with both attorneys general on this very issue. Jamaica, in fact, asked me what was the issue. And then I explained to them that their constitution is different from ours. Because what passes there easily is often a journey here for us. Because they have an exception in their constitution which we don't have. Madam Speaker, I can see no reason for us to not support this bill with the proposed amendments that I've articulated so far. I look forward to hearing from my learned colleagues. I thank all members of the Joint Select Committee for their unanimous support. I thank the members that gave their hard effort. I thank the parliamentary staff, the Attorney General's office, the Parliamentary Council that worked with us so diligently, and I beg to move.
Honourable members, the question is that this House adopt the report of the Joint Select Committee appointed to consider and report on the Anti-Terrorism Amendment Bill 2018. All in favour say aye. Aye. Any against? The ayes have it. The report is therefore adopted. Attorney General.
I'm just receiving the procedure, Madam Speaker. Much obliged. Madam Speaker, forgive me, Madam Speaker, just let me clarify. In accordance with Standing Order 66-4, I beg to move that a bill entitled An Act to Amend the Anti-Terrorism Act, Chapter 1207, be forthwith read a second time. Thank you.
Honorable members, the question is that a bill entitled An Act to Amend the Anti-Terrorism Act, Chapter 1207, be forthwith read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Anti-Terrorism Act, Chapter 1207.
Attorney General.
Madam Speaker, as provided by Standing Order 68-1, I beg to move that the Anti-Terrorism Amendment Bill 2018 be committed to the Committee of the Whole.
Honorable members, the question is that the Anti-Terrorism Amendment Bill 2018 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Members, are we ready? AG? All right. All right, the committee is now in session.
Clause 1.
The question is that clause 1 stand part of the report.
Of the report or the bill?
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no.
Division?
I think the ayes have it. Clause 1 now stands part of the bill. I will only allow the division if it is required in law, if that I'm not certain by the voices. Clause 2.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that Clause 3 stand part of the bill. The question is that Clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill. The question is that Clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that Clause 5 stand part of the bill.
Madam Chair, the government has not circulated an amendment to Clause 5, but I raised it in my contribution as something which we had just observed. I see that the Leader of the Opposition has also circulated an amendment to Clause 5. That which the government proposes is to be found at, it's in relation to the 1988 committee, Madam Chair. So it's to be found, remember, Madam Chair, for members' orientation, because there's so many papers before us, we're dealing with the bill as it's reported from the report. So in that report, there's an amendment which is recommended that has the 1988 committee, and it is there that we propose, that will be at page 350 of the report. And we are proposing specifically where the defined term 1988 committee appears, that we delete that and substitute instead the following words. Open quotations, 1988 committee with a capital C, close quotations, means the Sanctions Committee, capital S, capital C, established by the United Nations, capital U, capital N, pursuant to, capital A now, Article 30 of United Nations, capital U, capital N, Security Council Resolution, capital C, capital S, capital C, capital R, 1988, open brackets, 2011, close brackets, semicolon. So if I could repeat that, please. 1988 committee means the Sanctions Committee established by the United Nations pursuant to Article 30 of United Nations Security Council Resolution 1988, open brackets, 2011, close brackets, semicolon. The government does not propose any other amendment other than that, and I apologize for not having written that in the circulated form.
Did you take care of removing the word Taliban from
Yes,
the
ma'am.
definition?
Specifically, yes.
Okay.
Yes,
Indulgence as to how we proceed, Madam, because AG has amendments to disclose, and so does the opposition.
Right, so I think what we will take them as, we'll take all the proposed amendments under the particular clause, which we'll say amendment 1, 2, 3, and then we will put the questions in respect of each.
Thank you
so
for
that
your
for the
guidance.
government one, we will see as amendment 1 to clause 5. Yes?
Yes.
Yes. Leader of the Opposition.
Madam, I propose that we amend Clause 5, which is the definition clause, in two respects. And this is circulated on page 1, read Clause 5, list of amendments to be moved by the opposition. And here is to include a definition for central authority. The central authority is already contained in the law, but some of my proposed amendments later on includes making further amendments to include the central authority. Whether those succeed or fail, Madam, there is the central authority mentioned. You read the section earlier, and I propose that we give the definition, which means the personal authority, as circulated, Madam, being the personal authority as designated under the Mutual Assistance in Criminal Matters Act, Chapter 11, 24. That's the first proposed amendment. And the second proposed amendment is to insert a definition of the Director of Public Prosecutions. This is already mentioned in the law, but there's no definition in the definition section. And further amendments that we wish to propose includes inserting the DPP. So whether those down the road fail or succeed, these two are not ocious. You still have a need for these two amendments. Do I need to talk to it, or?
Well, it's up to you if you wish to talk to the amendments.
Sure.
I will, if you wish to
Well,
develop
if there
it,
is
and
no
then I will.
objection, then if there is, then we can talk to it.
Attorney General.
Sure. Madam Chair, without crossing beyond the confines of Clause 5, which is to seek an amendment to define the central authority and the Director of Public Prosecutions, subject to one minor amendment to that proposed by my learned colleague, in principle is not objectionable because central authority is referred to in Section 33, Section 32 of the legislation and elsewhere in the Parent Act. So too is the Director of Public Prosecutions. It hasn't caused a problem for the many years since 2005 that that's been in place. So from that point of view, there's no objection to that. That is squarely within the confines of Clause 5. Later on, we may.
But, so for now, we're just talking about for the definition.
Yes, Madam Chair. And with respect to that proposed by my colleague, the only thing that needs to be attended to from a drafting perspective would be to delete the reference to Chapter 1124 for central authority. So it would just end at the word act. So central authority means the person or authority designated as the central authority for Trinidad and Tobago in pursuance of Section 3 of the Mutual Assistance in Criminal Matters Act, and then the side note would have the reference to the Act. And so delete Chapter 1124.
The rest of the amendment is accepted. Is that what we say, sir?
Yes, sir. Yes, ma'am. And those are agreeable, Madam Chair, because the terms appear in the parent law as it is.
Okay. Okay, so the question is that Clause 5 be amended in terms of Amendment 1 as proposed by the government, Amendment 1 as proposed by the opposition, and Amendment 2 as proposed by the opposition.
Save and accept. Delete.
Chapter 11,
24.
24 to central authority.
Yes.
Yes?
Yes, ma'am.
Okay. So the question is that Clause 5 be amended as follows: to amend, in terms of the amendment, 1 to Clause 5 as proposed by the government. In terms of the amendment, to the first amendment to Clause 5 as proposed by the opposition, save and accept the words Chapter 11, 24, which are to be excluded, and Amendment 2 to Clause 5 as proposed by the opposition.
Yes.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that Clause 5, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Clause 6.
The question is that Clause 6 stand part of the bill.
Madam Chair, if I may just inquire, neither government nor opposition have any amendments in clauses 6 to 21 inclusive. Would it be amenable to the business of this House if we were to consider them together?
Whip? Okay. Thank you.
Clauses 6 to 21.
The question is that Clauses 6 to 21 stand part of the bill. The question is that clauses 6 to 21 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 6 to 21 now stand part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. Attorney General.
Madam Chair, should it please you, the government proposes in clause 22 that we cause two amendments. Firstly, to section 15B as the report from as the amended bill from the committee, the Joint Select Committee proposes, and also to section 15D as that report also proposes. The amendments are in the text circulated by the government, and in the first instance, in respect of 15B, we propose that the order which the minister may make for the declaration of a geographical zone be subjected to negative resolution. It meets with a similar recommendation by my learned colleague for Siparia with respect to clause 22 in the first item that the member has proposed as circulated. In the second instance, the government is proposing in section 15D to insert after subsection 2 a following new section, subsection 2A. And just to read it into the record, it is that prescriptive language which we use for adults, where we had provided for adults that they should no later than 30 days upon return provide the commissioner with certain information. We are proposing that that also apply with respect to children. So the language is that as circulated. It comes from an observation from my learned friend for Siparia, where the observation was made that we were not in harmony with the prescription for adults. Those are the two amendments and the rationale for them as circulated by the government.
Okay, Leader of the Opposition.
Thank you, Madam Speaker. Madam Chair, the amendment being proposed by the government at A, capital A, clause 22, capital A, is in fact identical to amendment common E with respect to clause 22. So I think the government took our comments on board. I want to thank them for that. With respect to B, again, I have not circulated this, but the AG, when I spoke of it in the debate, did undertake to do this, so we also have no objection to capital B for clause 22, circulated by the government. This clears the difference in language when a child is traveling as versus when an adult travels. So we are very happy to see those two amendments, Madam. We have no objection to those. We do have a further amendment to this clause. Should I deal with that now? Or?
Yes, please.
Yes. Which is clause 22, proposed amendments to be dealt with by the opposition. Common B, so A as circulated is identical to the government's capital E. Common B in our list of amendments, we want to suggest here that to insert a new subsection where the Joint Select Committee on National Security may review a declaration before the end of the period during which a declaration made under subsection 1 may lapse or be revoked by a minister, so that there would be parliamentary oversight of where a declaration is made to have an area listed, what is it, look as a geographic zone. And there are very adverse things that can happen to people who go to these designated areas and return. And therefore, it is very important that there is a transparency and public openness of these things taking place. So a person could go there and be caught, never even knowing that the area is declared. They would have been outside the country. Trinidad and Tobago decides to declare. They don't know. So there is this openness as well that the GSC, and again I renew my previous comment, which is a segue about the chairmanship of that committee. Nevertheless, we will ask this GSC be inserted for parliamentary oversight.
Right, Attorney General.
Sure. Madam Chair, I appreciate and understand and thank my learned colleague for the reflection. The reason why we can't accept it, or I'd like my learned colleague to think about it this way, is that technically orders go before the Statutory Instruments Committee. And therefore our prescription under our standing orders provide for it that way. Philosophically, I agree with my learned colleague, but now we're running into difficulties as to which committee has priority over the other. The reason for us not wanting to accept the amendment in prescriptive language in the law is that there is nothing to stop the National Security Council of its own volition from causing it to come onto the agenda. But in any event, it must go to the Statutory Instruments Committee as a matter of fact. So it was only for that reason that we didn't warm to the express language offered by my learned colleague. I think that the spirit of what my colleague is proposing is definitely something which falls into the garden of the government and is welcomed. It is something which the Parliament does of its own accord and as a matter of routine for the Statutory Instruments Committee, and then the National Security Council, the Joint Select Committee established for National Security has that privilege in addition to that.
Yes, thank you, ma'am. Whilst I would prefer that we insert this parliamentary oversight, especially given the kind of draconian powers that are being given to the executive in this piece of law, we understand the need for it. What harm is there, if I may ask the AG, what harm will it cause if it is inserted? Will it cause any harm?
Yes, the harm that it would cause is that it would usurp the functionality of the Statutory Instruments Committee. But in any event, we've agreed, we think it very sensible that we subject the order to negative resolution in any event. And we've also taken this suggestion, the Joint Select Committee agreed to this, that we specifically inform the Leader of the Opposition, because this is of national importance. And one can't take the view, whilst it's true that the executive ought to have the ability to be the executive and to have that functionality, we've broadened the perspective in the Joint Select Committee. So it is only for the collision with the Statutory Instruments Committee, but there is nothing that prohibits right now the National Security JSC from considering this matter.
With the greatest of respect, there's a great deal with the existing situation that will prevent it ever going there. Your chairman.
So let me work it out this way. The Joint Select Committee on National Security may review a declaration. And then what?
Then
what can it compel as a result of that?
Well, it's the same thing when you inform the Leader of Opposition. What does it compel?
Yes,
Now,
but
wait.
Sure.
Taking your argument down the road, what does it compel? It compels a public debate of this particular matter. It brings it to the attention of the public who may be affected by, as I say, traveling to these areas, being caught in areas. How many people read a Gazette?
Agreed, which is why we have the
I think many of us
negative
sitting right here don't read the
resolution,
Gazette.
which is why we have it for negative resolution. So that has been the law always, but what we have agreed, and the Joint Select Committee considered it specifically, put it for negative resolution, subject it to negative resolution. It is therefore something, it isn't, now mind you, it's very different, you know. Most things run the risk when they're for negative resolution of not being caught. Yeah. It was laid on the table, the 42 days, he didn't notice it. In this case here, the JSC has said, don't stop there. When the minister does this declaration, he must specifically inform the Leader of the Opposition. And then the Leader of the Opposition is positively informed and has the option to raise a motion for negative resolution.
Anybody else want to come in, or should we let this one go?
Member for Urupuj is?
Yeah, thank you very much, Madam Chair. I'm happy that the Attorney General recalled that this matter was raised and discussed. And I just wanted to reiterate the fundamental difference between sending an order to the Statutory Instruments Committee and giving the power to a Joint Select Committee that may review. They may not review. But in circumstances where information arises on the listing on actions taken by the executive, to give the Joint Select Committee a power in the law that they may review also will mean that that committee can call persons who are affected, or communities who are affected for that matter, to come before the Parliament in public, not in camera, but in public. And they may well have an opportunity to voice their concerns, to raise questions, but also to make
Monsieur, I am listening.
Yeah. Yes, thank you. The Statutory Instruments Committee would have a fundamentally different function. It is an administrative function that may or may not lead to a parliamentary debate to negatize an order. But that is fundamentally a debate among members of Parliament in the House. But placing this matter and giving the statutory right to a joint select committee to, if they so decide, to review an order means that the affected persons, entities, or related entities or persons can come before a JSC, explain themselves, raise the matter in public. You have the public awareness, you have the public education in some cases, sensitivity, and bring to me and to us here greater transparency, greater openness on this sensitive part of the operations of the anti-terrorism bill. And that is why it was raised in the Joint Select Committee specifically, because while we know that any matter the House of Representatives can refer a matter to the Joint Select Committee, A, B, or C, to put that in the law means that those persons affected or related persons or entities may have an opportunity to come before and be heard. When we are debating a matter here, nobody can be heard except those of us in the chamber. And this is why we were reiterating and really emphasizing that this really is a best practice or a good governance approach to the matter.
Madam Chair, I thank my learned colleague for his submission. It is certainly something which the Joint Select Committee itself considered. In the committee, we did not include, all of us, we didn't include it, specifically because there was the recognition amongst all members that national security and executive functionality as it relates to national security is a very specific thing. In particular, my learned colleague for Siparia, as a past head of the National Security Council, will know that there are some things that a National Security Council will be aware of that it can't itself speak about publicly. One may have information which is not yet evidence or cannot be treated within a particular way. It was for this very delicate balance of positions that we felt that it could not, and when I say we, I mean the Joint Select Committee, that we ought to leave it the way it was. We had a fulsome discussion on it. Let's step beyond that now, and the submission of my learned colleague. Members of Parliament do represent people. It's true that other persons can't appear before the Parliament in its sitting other than by way of a committee, but there are umpteen other mechanisms by which committees of Parliament can go to work, including the Statutory Instruments Committee, and including the fact that we can have specific motions for matters to be referred to elsewhere.
Member for Chaguanas West.
Thank you, Madam Chair. I listened carefully to the Honorable Attorney General, Madam Chair, and I get the impression that the executive is taking this matter of secrecy in the context of national security to hide a level of incompetence and potential abuse. So what we are saying is that if you engage the Joint Select Committee, you have an open, transparent process to determine that whether or not you're in compliance with the listed criteria for establishing a geographical area. And that therefore, I do not see any kind of, to echo my colleague, in the context of good governance, I want to disabuse this approach where national security in a matter sensitive to a significant section of this country, that you eliminate the shroud of secrecy associated with that in the context of a Joint Select Committee.
Member for Port of Spain North, St. Anne's West.
Thank you very much. Madam Chair, this is dealing with an executive decision to declare a geographic area where the legislation says it can't be a full country, a designated area for a specific period of time. Let's start with that. I just heard my friend from Chaguanas West say a significant portion of the country. We've made it clear this is not dealing with any particular religion, etc. So just to bring that back into context, for example, it could have been in Ireland, a specific section or town in Ireland that the IRA are very active in and teaching people to make bombs, etc., and the whole world takes a decision. People going there are only going there for one purpose. So I don't know what he's talking about outside of terrorism itself. But the talk about abuse, etc., none of this, and persons who are affected, they still have their rights to go to court and to judicially review any decision that an executive may take to designate an area, a specific geographical area, based on evidence it may have that it may not be permitted to. Because very often in these types of matters, the intelligence agencies that provide the evidence to a country are very specific, and it is on the condition that you do not broadcast the intelligence. So the behavior as though secrecy is something new in dealing with issues of terrorism, I find a little bewildering. But the point I want to make is there always remains protection by allowing a negative resolution. It can be brought before the Parliament, and the government wouldn't not allow it to be brought before the Parliament. By saying that persons have to come before a Joint Select Committee to make their submissions, if their rights are being trampled on in the declaration of an area, a geographical area, they can go to court, and that is the protection that is provided.
Madam Chair, just before my learned colleagues go further, there's one very, very important point to be added to this, and it's in offering to the contribution of my learned colleague from Chaguanas West. We must bear in mind that Trinidad and Tobago does not have the kind of Official Secrets Act and legislation that other countries do. And that is a very critical linchpin to consider, because that Official Secrets Act is what guides processes for external review in other jurisdictions. This is a very important functionality that we must consider. So in causing this balance to be had, again I caution, we must not take apples and compare them with oranges or watermelons. And it is that lack of official secrets legislation which concerns me deeply. The other thing is this: national security of this type is generally driven by foreign entities providing intelligence and information. And the strictures of confidentiality imposed are very sincere. And the risk of exposure to persons who may cause harm, etc., to informants or to intelligence operatives is also a very critical thing to be had. So it is only in those circumstances that I ask my learned colleagues to rely upon the Statutory Instruments Committee, the fact that the Joint Select Committee on National Security may operate itself in any way it chooses, and more importantly, upon the privilege of the ability to negative the order.
Member for Laventille West.
Thank you very much, Madam Chair. Madam Chair, just to follow on from the point as established by the member for Port of Spain North St. Anne's West, what is subject to negative resolution is the declaration by the executive of a geographical space. And the member for Oropouche East made the point that it will allow an individual to come before the Joint Select Committee on National Security to put his case. This is not ad hominem law. It cannot be. This is general law for all concerned. So that if an individual is adversely affected by it, the remedy has to be along the lines as espoused by the member for Port of Spain North St. Anne's West, rather than to come before a Joint Select Committee and put your case. The best the Joint Select Committee could do is make recommendations to the Parliament, and the Parliament could attempt to sanction the executive. But the remedy for an individual is the right to go to court if he's adversely affected by it. So I agree with the Attorney General that it doesn't do any harm to an individual, and in fact he has his rights that can be protected otherwise. Because what you have for negative resolution and what they want, the opposition is proposing to be the subject of deliberations of a Joint Select Committee of the Parliament, National Security, is the declaration. And it is not ad hominem. It cannot be. And that's the argument.
Professor Beria.
Madam, ad hominem and so on sounds very nice. I don't see the relevance of that. With the greatest of respect, I support the contributions of my colleague, and I would ask the AG again, what harm is there by inserting this GSC? The point made by my colleague from Oropuch East is very, very important in terms of allowing people to come before GSC to share their views, where it might be whole communities that are involved. But above all, your government has modeled a lot of this legislation from the Australian model. And the wording we have put in this is identical to what is in the Australian Criminal Code 119.37. It is an identical parliamentary oversight provision. I ask again, what is the harm that can accrue? I'm being told about sensitive national security matters and so on. Well, of course, we have a GSC on national security, and of course, there will also always be those, but that should not preclude the openness and transparency that a GSC would provide for any activity that is taking place on the part of the executive. Again, I fail to see why the government is concerned to keep this whole thing, to have a secrecy. So please tell me what harm will be caused by inserting this provision. If you can convince us that the harm is sufficient to outweigh the benefits that may come, well, we may well change our minds.
Attorney General.
Yes, Madam Chair. My learned colleague has referred to the Australian model, and my learned colleague is correct. But the Australian circumstance is dramatically different from that in which this bill is intended to operate in our laws. We do not have sequestration of evidence. We do not have non-disclosure provisions. We do not have extensions of detention and sentences. We do not have the official secrets laws that Australia has. We do not have the severe criminalization that they have. It was for that reason that they have reviewers, etc. For us to compare a standard without looking at the substrata from which that standard comes is a very dangerous thing. And I've taken extreme care to point that out, because the adverse inferences on the remaining silent, etc., and none of that prevails in our jurisdiction. It's the exact opposite. In fact, I dare say that it's a very hard climb for a prosecutor in this country to secure conviction because of the manner in which our evidence laws operate. And in fact, we proposed in the Joint Select Committee consideration of the type of evidence amendments that we perhaps as a country need to consider. But we decided, at least in our discussions, that that should be the subject of separate law. We didn't want to conflate the two. So the rationale for caution is in the round as I've just described it. The mischief is, what could the harm be that my learned colleague is asking? The harm is that we do not have the substrata protections that the other jurisdictions have. And it is only in those circumstances that we recommend reliance on the negative resolution process. In any event, I am able to say confidently that the National Security Joint Select Committee can still do what it wishes. So there is nothing that can cause that otherwise. But in any event, as my learned colleague for Laventille West put it, at best one can have is a censure, because it is always going to be the case that the National Security Committee would have a majority of government members by any government. That's just the way our parliament is constructed. The correct remedy, as Port of Spain North St. Anne's West put, is really to be found in our courts, but the ventilation is to be found in the negative resolution.
Member for Princestown.
Thank you, Madam Chair. Honorable Attorney General, I get from you that you're not necessarily opposed directly with respect to the JSC, but really you're more concerned about the process of getting there. Could you say, with respect to considering the use of the courts, now, in that system, the law does not recognize issues of religion, etc. It deals purely with the law. And in those circumstances, with respect to other jurisdictions that have set up this GSC, the main purpose for that was to bring forward persons who would not have recourse before the law through the courts. Can you address some of those issues in terms of how do you think that that will work in the circumstances of a plural society like Trinidad and Tobago?
Member for Port of Spain North St. Anne's West.
if I may contribute here again, I'm hearing the reference to religion here, and I don't understand how that is entering the debate. This is to deal with terrorism, and it is very, very wrong, and I don't blame my friend from Princestown because he's not an attorney, he doesn't practice in the courts, but it is very wrong to say that the courts would not consider if somebody had an issue saying they were being persecuted on the basis of their religion. That would be the evidence that you would squarely put before the court and then apply the Constitution to, and the court would rule on it. So to say that you can't raise religion in a court is not true. I mean, right, recently there's a case with, I think, someone wearing a hijab and someone preventing them from being a OJT or something like that. That is squarely before the court, the burqa case, etc. So to say that the court system prevents anybody, and especially on the basis of religious persecution, because I understand that to be your concern, that someone will have an argument, I'm being persecuted against because of my religion, I want to go somewhere, because of my religion, I must go there. The court system is very, very open and is designed to protect that. As my friend for Lavantil West said, a joint select committee in Parliament can't offer any protection to anybody the way a court can. What can we decide in a joint select committee on Parliament? We can say, well, we don't think this is an appropriate way for the executive to go, whereas a court will rule directly on it. So I don't think that's correct. Just to touch on the Australian system, because it is something that we've looked at, and I was fortunate to have discussions with them recently, about a month ago. I would be thrilled if all of you all on the other side would say, bring the Australian legislation here and we adopt it wholesale. Because the type of powers that they have given the authorities there, when a person who has been sentenced for terrorism, their sentence ends, the police can go to court in an ex parte application and say, we believe this person continues to be a threat, and extend it.
Mr.
So I'm just saying.
You did
yes.
not bring those other parts of it. We have not
No,
brought
I'm
all
just
of
saying
Australia.
you
So
referred to
let's
it. No, you've
all right,
referred
one
to
at a
it.
time, Thank you.
So I'm referring to it as well. You are the one, Madam Honorable Member from Siparia. You are the one, allow me to speak. You are the one who said that you've seen and you've looked at Australian, etc. I'm just saying, as the Attorney General, you have to put things in context. So what you may have picked up about a joint select committee, if that is so, being utilized in Australia, is because, as the Attorney General said, it's a massive broad spectrum of very draconian provisions, not what we're dealing with here, which is simply the declaration of a specific area being a geographical area that someone needs permission to go to.
Thank you, Madam Chair. I regard this provision submitted by the Honourable Leader of the Opposition as merely a part of the continuous stream. When we established the Section 66A in the Constitution, Joint Select Committees, it was part of opening up the process of governance in the country. And that therefore this is consistent with that. The terrorism and counter-terrorism are the principal issues of the 21st century in the current climate, and will continue to be like that. So that therefore, this is legislation now dealing with that. So it is better that we err on the side of openness rather than err on the side of non-disclosure of these things. And that therefore, I regard this as merely as part of oversight and scrutiny of executive action. And therefore, it ought to be recommended to the House.
Madam Chair. Member for Lavantil West.
Madam Speaker, I just want to commend to the member for Siparia to observe two things as it relates to the Australian context which she raised, which the member raised. There is no offense in 15B, you would notice from your reading of it. There is no offense. It really sets up a presumption of a certain course of conduct. There is no offense. In the Australian context, it is a criminal offense. Therein lies the difference. The first offense that this section 15 throws up is in 15D sub 5, so that in respect of 15B, there is no offense. It merely sets up a presumption. in contradistinction to the Australian model where there is a criminal offense for going to a declared area. Here we have no such thing.
You see, Madam Chair,
Yes,
the criminalization of travel was a live issue for the government. We specifically felt that it would be very dangerous to criminalize. And all that we did in the round of the new Section 15 is to do two things. One, compel the fact that you must give notice if you've been to a particular area. You must give that notice either before you went, while you were there, or when you came back. And we provided loads of exceptions. If you had a lawful excuse that you couldn't do it, it was unreasonable that it should be done, etc., exculpation. The second thing that we did was to provide for the first time a benefit which none of our Muslims, in particular in Trinidad, could enjoy. Many of our Muslims were being mischaracterized as supporting terrorism through their financing by the facilitation of their zakat to entities. And for the first time, we have an ability to tell a foreign entity, you've got the wrong man. We have a reason, it's been declared, this person has been upfront with us, go and look somewhere else, not by our citizen. And this is something that our Muslim community in particular has been holding on to as a terrible burden. So in this particular context, it is very difficult to take the recommendations. My learned colleague for Chaguanas West raised a very important point, which we also discussed. That is the utilization of the PAC and PAEC under Section 66 of the Constitution, where we refer matters of a financial nature there. But I come back to the lack of official secrets. I come back to a very different environment, and this is a matter of very sensitive national security. And the last point that I'll make is, if you look to the standing orders as to what the National Security Joint Select Committee does, it is very clear. It has a broad ambit which can treat with certain workings, etc. So there are many bites at this cherry. One, informing the leader of the opposition. Two, negative resolution. Three, nothing prevents the Joint Select Committee having a view of certain aspects. Four, the Statutory Instruments Committee prevails. Five, we are not operating under the construct of this being a criminalized matter. If you travel, you're guilty. It's a presumptive aspect, so we are not comparing apples with apples.
So I'll take in this order Burupuch East, Princestown, Member for Siparia, and then AG, you may wish to wrap up on anything. Yes.
Yeah, thank you very much, Madam. Just three short points, really. The first is, I think, for the record, we should just confront this issue of secrecy and the importance of confidential intelligence information and so on. I think there can be no disagreement that in this matter, it may involve issues of confidentiality, intelligence gathering, and so on, which must always be protected. And this is why the amendment is so worded that the National Security Committee may review a declaration. It is not compelling the National Security Committee to review. It may. Now, all select committees, joint or otherwise, would always have, as the Attorney General said, a built-in majority of government members. And if it is the view of the government and or the executive that a particular declaration ought not to be aired at the Joint Select Committee on National Security because of the sensitivity of international intelligence gathered and so on, the Joint Select Committee has the government in a majority and would decide not to entertain a review. So the issue of secrecy, to me, don't arise in that context. It will always be protected. The second level of secrecy is that you may have the Joint Select Committee on National Security meeting. They may meet in camera, behind closed doors, where certain type of information may come out. We have enormous examples of that over the year. And for the record, I want to place my objection to this approach of the government and others, but the government, that when persons or entities or communities face a problem where they believe that their rights are being violated in one way or another, they may not have the evidence, they may not have proof of it, but it is their perception that they are being victimized and so on. This approach of take it to court, take it to court, take it to court, it is to me not the best approach. That involves lawyers, legal fee. It involves time. These things could take 12 years before you reach the court for a trial to determine something, whereas those persons or entities may find their way to a joint select committee, air their views, and if they may well be wrong, but at least they would clarify, and it would bring a better level of governance than depending. The court is there as a final arbiter. The court ought not to be the first arbiter in dealing with the grievances of citizens. I think the Parliament ought to do that. And finally, my third point then, whereas the member for Port of Spain, where is he? North, in response to Princestown, raised the issue, this is not about religion and so on. It's interesting, the Attorney General in his examples talk about how this protects the Islamic community from their practices. So whether we like it or not, it may sound nice that this is for all religion and this is for all people, and that is fine. It is. But there can be no doubt that a particular community has been affected or perceive themselves to be affected, because why are we changing all the Islamic words in the beginning for if this concerns all religion and so on? We must be careful of the sensitivity in the matter so that, yes, we deliberately took steps to ensure that no community feels aggrieved. But clearly we must be clear, as you are, I think, that one community as opposed to another would have a different level of perception and grievance. And this, I think, is understandable. Thank you.
Thank you, Madam Chair. A follow-up comment made by Urupuch East in response to Port of Spain North St. Anne's West. I think really the contribution in response to the point I was trying to make, raised by Port of Spain North St. Anne's West, really does not reflect the broad base in which this particular issue must be addressed. The Honourable Member really spoke to the issues in silos. And I'll make reference with this, Madam. In terms of if we are looking at the use of the courts to address these issues, first we must meet the legal threshold under the Act. And again, there are so many loopholes that do not constitute under, if it doesn't meet the threshold in terms of the Act. So,
referring to Judicial Review Act, is that what you're referring to?
No, I'm talking about the
Anti-Terrorism?
Yes, the Anti-Terrorism.
Sorry.
What I've said is,
it must satisfy the legal threshold.
I'd allow
Yes,
all
please.
these
I
speakers,
apologize.
and then you can deal with everything in a blanket. Member for Princestown, please continue.
That was really the point I wanted to make in terms of a follow-up to Rupuchi. It cannot happen just in silos. And that is why we see the purpose of wanting the JSC.
Member for Ziparia.
Thank you, Madam. The point about whether you're criminalizing it or not is true to a certain extent, but there is a presumption, you're presumed that you're a foreign terrorist fighter. So we could find that in Section 15B, 10 and 11, which says, 15B, 10 and 11, if you, a TNT citizen or a person resident in TNT who travels to, enters, or remains in a declared geographical area shall be presumed to have traveled for a purpose specified in presumed to have committed a terrorist act, basically, yeah? All right, and then you have 11. The presumption under that subsection will not apply to a person who has given notice and so on. So you don't have the notice provisions. But again, whilst you will not be locked up in the sense for a particular created criminal offense, if you're presumed to be a terrorist fighter, you presume, it places a person under a burden to clear themselves or not clear themselves to go through a process. So there is an adverse effect on a person who should find themselves in this kind of circumstance. So I hear you about the offense, but there is a presumption that you're a terrorist fighter. And that in itself has serious adverse effects on any individual person. The second point I would like to make is that this is not just about the breaching the rights of people. And there's a large percentage of our population, about 12% of our population of Trinidad and Tobago. The last CSO statistics is about 12% are of the Muslim faith. So that percentage of our population may find themselves outside whatever parameters you have set here, go somewhere, come back, and it's presumed to be a terrorist fighter. That's my first concern, and therefore I agree with my colleagues, and especially Old Pitch East, about trying to protect 12% of our population who may be circumstanced in an adverse manner from your provisions. The second thing, it is not only just about rights of citizens in my submission, it is also, there is also something that has well, I see the AG is busy. Yeah, you can multitask, I see. The other issue has to do with, it's not simply an issue of the breaches of rights. See, when not admitting the explanations you have given, there is also the whole issue of foreign affairs, where a minister of government of our country declares a part of somebody else's country one of these zones. And therefore, that impact it could have on foreign relations with other countries. I mean, right now, our foreign relations with Venezuela, you have two sides to that story. You have a lot of things that are happening. In the same way, you designate somebody else's country, a part of it or whatever, into this kind of area, which is saying, you know, you're presumed to be a terrorist fighter once you've been there. It places, you know, there must be a burden, a responsibility on the part of a government to be called to check. So those persons can't come and go to court here, you know. Our foreign relations can be affected. So I've designated a part of Iraq, designated a part of Saudi, wherever it may be, here in Trinidad, placing our citizens in a certain kind of circumstance. And the foreign country said, but no, that's not so, it's not true. And so the I am being disturbed, madam. And so, madam, we make a plea again for this particular amendment to be accepted. We leave it in the hands of the government at this time.
Hold for a while, let me just take Member Shagona's piece.
Thank you, Madam Speaker. Madam Speaker, I just would like, since the Attorney General indicated that this was a part of the discussions with the Muslim community, I want to indicate that the stakeholders of the Muslim community did in fact commend you for they did in fact commend you. Many of them were here on the occasion when we started this debate for the manner in which you were open to them and you accepted their contributions. To do anything else would appear to the members of the Muslim community to be contrary to the spirit of the openness in which you accepted their contribution. Let me also say, and you will know the word very well, which I'm going to use, that the whole concept of this aspect of what we're discussing now is what is called shura, or consultation. And therefore, the members of the Muslim community in this context will be more akin and better. They'll feel a sense of warmth and reception to come and give you their views as opposed to going to court, which may imply to the members of the Jamaat or to the Ummah, the body of Islam, that there's something to prove for which they are not really liable.
All right, I'll entertain Baratari Sanwan and then I'll call on the...
Thank you, Madam Speaker. Honorable Attorney General, I want you to just think about this. This subsection is indicating that the Joint Select Committee on National Security may review, not shall review. So what I'm saying, it gives the approach to a rapid movement rather than a court order. Court cases last a very long time. So I'm agreeing with the Leader of the Opposition. I think maybe if you look at it in the light of may review rather than shall review, it may or may not happen. So I see no harm in this clause.
Member for Diego Martin West.
Thank you, Madam Speaker. Madam Speaker, I just want to, for the record, respond to the member for Siparia, who has what appears to be an emotive concern. And the member made,
assist.
The member is pressing this point on the grounds that it could harm persons who would have gone to somewhere as a result of their community's urgings or whatever, and come back and find that they have run afoul of the law and they are deemed to be a terrorist because they went to somewhere that they didn't know. Madam Speaker, that runs counter to the letter not even the spirit, the letter of what we're trying to do here. Because for that to happen, it means that the areas that would deem to be prohibited would have been done in secret. And some person could have gone to that place in that country and not know that there was a designation that that zone was deemed to be an area of conflict or something like that. That is not what the law is saying. So there's no chance of anybody traveling on vacation somewhere, going on a religious pilgrimage somewhere, and come back and find that they are now deemed to be a terrorist because they went there. That is quite misleading. And that is the kind of conversation that is causing the disquiet in our national community. Because people are twisting what is in the law. The law says that if a place is designated, and that means that it will be designated in public. And therefore, no person can go somewhere and come back and say, I am being charged for going to a place that I didn't know was a place that I shouldn't go. And if you did go there, there are provisions to determine if you went there innocently or for good reason. The law makes provision for that. So this concern that is being raised here, Madam Speaker, has no merit at all, because that is not provided for under the law. And secondly, arguing that you are protecting the 10%, 12% of the population. The government is protecting 100% of the population, which includes that 12%. And I'd like that to be on the record.
Yes, please. Attorney General.
Thank you, Madam Chair. Madam Chair, I thank my learned colleagues and my colleagues on my bench for the fulminations. And if you'd permit me to address the issues raised in summary. Perhaps I should do this, as one must in every debate. I declare my interest. I am entitled to Iraqi citizenship, as I am a Trinidadian citizen. And in fact, the people most at risk of the application of this law are mostly the Christian Arabs in Trinidad and the Muslim Arabs in Trinidad who have to travel to see family, as I do. That's a fact. The risk to the Muslim community, as this is being portrayed, is perhaps a little bit under that. And I want to be absolutely clear. I notice that we're skewing this debate towards Islam. And that is a very dangerous thing, because this bill is to treat with terrorism. Secondly, my learned colleague for Oropouche East said something which was very true. We remove the Arabic references specifically to move away from the perspective that this thing could be treating with Islam, even though I personally feel that the use of the word ISIS could only ever mean a terrorist organization, the same way we use the expression Nazi to mean the Nazi empire that prevailed in its atrocities as it did. I could never associate, or Ku Klux Klan, I could never say that ISIS referred to by the UN is in reference to Muslims. That could never be the case. Madam Chair, the Honorable Prime Minister was correct. This law is designed specifically to protect 100% of our citizens, all of them. There are acts of terrorism in South America. If we look to La FARC, as it exists between Colombia and Venezuela, we just had a massacre of 12 people off the coast of Guyana, where FARC is operating. So this is much more than just Islam. Madam Chair, in answer to my learned colleague from Princestown, I couldn't understand the reference to the legal threshold under this act in terms of somebody who is affected by the law. The right which my learned colleague, the member for Port of Spain North, St. Anne's West, was referring to was under judicial review. And that's a very low threshold, I should add, because the leave to get judicial review is on a bare minimum threshold level. In any event, the point is, all that this positioning is going to do is back to what is the existing position. If you look to the standing orders and you look to our Parliament's practice, nothing preempts the National Security Council from doing whatever it wants to do. However, prescribing it positively runs afoul of the issue of the Statutory Instruments Committee. And secondly, puts in a mandatory concern, because may can always mean shall. It puts in a mandatory concern which is troubling from a national security perspective in the compellability of witnesses. And where you are relying upon foreign entities and your local entities in respect of their surveillance and information, we cannot risk exposing persons to that. Public accounts is very different from national security. We're talking about lives in this arena. And it is in those circumstances that the government, in an effort to protect 100% of its citizenry, has to err on the side of caution. This declaration of the zone of the country, of a part of a country, is done publicly. When it is done publicly, it is done before it is made by informing the leader of the opposition. There is the ability for the order to be subjected to negative resolution in the Parliament, an open and full parliamentary debate. But in that process, we are not compelling witnesses to attend. And that is the danger that we must focus upon. This is national security and lives, Madam Speaker. Furthermore, anybody caught under the prescription of Section 15, as this is proposed, there's a presumption, and that presumption is discharged by lawful excuse. I did not know while I was in Syria that you had declared Raqqa, which is part of Syria, and I went to visit my cousin. I came back, I found out, I'm telling you now. There is no criminality associated with that. This predilection, this leaning towards saying that we are treating with Muslims is very dangerous. The government is protecting the Muslim community, the Christian community, the Hindu community, but we are specifically providing a benefit which never existed for our Muslim brothers and sisters in having the ability to tell foreign entities that mischaracterize their contributions that they've got the wrong people. In all of those circumstances, it is with utmost respect that I respectfully cannot accept the recommendation of my learned colleagues, though I understand the spirit in which they have offered it.
All right, so that the question is that Clause 22 be amended as follows. In terms of Amendment 1 as proposed by the government and Amendment 1 as proposed by the opposition. Those in favor say aye. Aye. Those against say no. I think the ayes have it. In terms of Amendment 2, as proposed by the government. But we finished it. Okay. All right. We just voted on Clause 22A under the government's list and under A under the opposition list, which are both the same. Okay. We are now putting the question as regards to B under Clause 22 on the government's list. Okay?
Which is the 30-day prescription period for the children. Yeah.
All right? The question is that Clause 22B, Clause 22B amended as follows, Clause 22B, BE, amended as follows. In terms of Amendment 2 as proposed by the government, those in favor say aye.
Aye.
Aye. Those against say no. I think the ayes have it. In terms of Amendment 2, as proposed by the opposition, which relates to the Joint Select Committee on National Security. The question is that Clause 22B amended as follows. in terms of Amendment 2 as proposed by the opposition. Those in favor say aye. Aye. Those against say no. No. Okay? Take a division on this.
Mr. Alwari?
No.
Dr. Rowley?
Members, could I have some attention and please?
Dr. Rowley? Yes. Mr. Young?
No.
Mr. Imbert?
Absolutely not, no.
Mr. Dialsing?
No.
Mr. Ford?
No.
Mr. Hines?
No.
Mr. Mitchell?
No.
Ms. Cujo?
No.
Mr. Garcia?
No.
Mrs. Critchlow Coburn?
No.
Mrs. Robinson Regis?
No.
Mr. Dillon?
No.
Mrs. Webster Roy?
No.
Dr. Gadsby Dolly?
No.
Dr. Francis?
No.
Miss Oliver?
No.
Mr. Antoine?
No.
Mr. Leons?
No.
Mr. Smith?
No.
Mrs. Jennings Smith? Mr. Lee?
Yes.
No to you.
Mrs. Pasadbi Sasso?
Yes.
Mr. Charles?
Certainly, yes.
Dr. Ramachan?
Yes.
Mr. Karim?
Yes.
Dr. Tiwari?
Yes.
Dr. Munilal?
Yes.
Mrs. Nuwalu Hussein?
Yes.
Dr. Gopi Singh?
Yes.
Mrs. Gayadeen Gopi Singh?
Yes.
Mr. Indar Singh?
Yes.
Mr. Ramadan?
Yes.
Dr. Khan?
Yes.
Mr. Padarat?
Yes.
Dr. Budo?
Yes.
Mr. Pari?
Yes.
Ms. Ramdial?
Yes.
Mr. Singh?
Yes.
Honorable members, the result of the division on Amendment 2 to Clause 22 as proposed by the opposition is as follows. 21 against, 18 for, with no abstentions. So the proposed Amendment 2 to Clause 22 as proposed by the opposition is not carried. The question is that Clause 22, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Madam Chair, may I just remind that I have been referring straight through to the report of the bill which came from the committee, which is different from the bill itself, because it is that proposed amended bill which we just dealt with at the report stage. So for the record, the amendments that I have been proposing are in relation to that which was proposed to be the amendments coming from the committee. Specifically, that is contained in what is referred to as list number 1 of our amendments in the report, and that is to be found at page 357, if I'm not mistaken. So the government's amendments are technically list number 1, which is at page 357, which is the list which the committee agreed to unanimously, and list number 2, which is what we're now discussing. So perhaps if we were to take the break whenever the break comes, if we could just ensure that we are literally on the same page, because the amendments that the government is referring to must include list number 1 and list number 2.
Yes.
We shared some words across the floor. It is our respectful view that what we've been doing is not the correct process. So that if we take the break when you decide, the Honourable Attorney General will share with you what we have discussed, because we have to put each of the amendments in the list of amendments, the list of amendments, page 357.
Yes.
You will note it says list of amendments to be moved by the Attorney General in the House. We have not moved any of those, madam.
So what we've done is part 1.
Can we agree that we will revert backwards when we reach to ensure we cover all these? We are close 22 now, you see.
Okay, so when we resume at after the suspension, we will go back to list 1.
Yes, because we've only done half so far. So we're dealing with list 2. If you notice, Madam Chair, you'll see on the list circulated that we've been discussing, at the top right-hand corner, you'll see 29th June 2018, list number 2. So just reminding you that we do need to deal with list number 1, and the member for Siparia and I are on equal page as it comes to this.
All right. So would now be a convenient time to take the suspension?
Should it please you.
All right, so this sitting of the committee is now suspended to 5 o'clock.